Hello, I'm Eric and I'm giving a talk today on consent. A little bit about me first. I qualified in Manchester Dental School in 2001. I've worked in general practice since and combined it with being a clinical teaching fellow at Manchester Dental School until last year. I then became a dental legal advisor for the DDU in 2014 and shortly after completed a medical law master's at Cardiff University. The aims and objectives are to understand the principles of consent, what's meant by mental capacity, to appreciate the importance of explaining material risks, and to go over the legislation for minors and adults who lack capacity. This meets the General Dental Council Development Outcomes A and D. And about the DDU. The DDU is a specialist dental division of the Medical Defence Union Limited, the UK's leading medical defence organisation. We are a not-for-profit mutual organisation owned by our members and wholly dedicated to their interests. We are led and staffed by dentists with experience of the pressures and challenges faced in practice, and we have an unparalleled track record of helping members overcome the challenges which could threaten their livelihood. Although this is an old definition, it's one of the most succinct definitions I've read. It talks about consent being voluntary, continued, the patient receiving particular treatment is based on an adequate knowledge of the purpose, nature and likely risks of the treatment, and that it's an ongoing process. Permission given under any unfair or undue pressure is not deemed as being consent. There's some evidence that patients are less likely to litigate if they've been fully involved in decision making, even if the worst case scenarios come to light. At the DDU, we often deal with matters which seem to arise from the patient feeling like they were not involved in the decision-making process, but went along with the treatment anyway. When something goes wrong, they often feel particularly aggrieved because they feel it wasn't their decision, but they've been harmed or disadvantaged by the procedure not going according to plan. Ensuring a joint decision-making process, therefore, remains key. There are three main elements to consent. You've got to consider the competency of the patient you're treating. You need to establish if the patient themselves can consent to the treatment being proposed. Children may need to have an adult with them. If you consider that the adult can't give consent to an adult can't give consent to the consultation, you'd need to consider if it's appropriate to involve somebody else. You also need to provide the patient with sufficient information. Providing patients with information can be more challenging now because surgeries are set up limiting materials that could be contaminated during an AGP, things like models, leaflets, etc. Routinely in practice, I still use models, pictures, etc., but we tend to use them in a different room to the surgery. But it's something you do need to bear in mind now, and I'm sure you've all sort of experienced difficulties with that since the changes in 2020. Patient needs to give the consent process has to be voluntary, so the patient needs to not be coerced into providing their consent to the treatment, so they shouldn't be pressurized in any way. Historically, the Hippocratic Oath exemplified the fundamental modern ethical principles of beneficence, non-maleficence and confidentiality. But as Robert Veitch, the professor of medical ethics and philosophy, put it, the Hippocratic ethics saw the patient as a weak, debilitated, childlike victim, incapable of functioning as a real moral agent. And it didn't mention at all patient autonomy, patient's role in the decision-making process. A patient being involved in the decision-making process is a concept that was adopted in the 20th century. Before this, it was treating the patient with something called medical paternalism, which is making a decision on behalf of the patient. By the late 1990s, landmark decisions in countries, including the United States, Canada and Australia, firmly moved the law into these countries towards patient autonomy. One of the cases that really stood out to me was the Rogers and Whittaker case, which is an Australian case of a lady who was impaired vision in her right eye from a childhood injury. She was offered surgery later in life to improve the appearance of the eye and hopefully improve the sight, but she wasn't warned of a very small risk of sympathetic ophthalmia, which is a low risk leading to blindness, and it could potentially involve both eyes. And unfortunately, she did become blind in both eyes. Our equivalent of this is the recent Montgomery judgment. Before that, our duty was to warn patients of the risks based on whether they'd acted in accordance with the responsible body of opinion. So it was more looking at the decisions made based on what another dental professional would consider appropriate. The Montgomery judgment moved it more towards what the patient might consider appropriate and what a reasonable person in the patient's position would attach significance to particular risks. Some practical tips on obtaining valid consent from patients. You need to discuss all the alternatives, including the option of doing nothing. If a patient's in pain, they might decline treatment, and although that decision might be considered unwise, doing nothing may still be an option, so it is one that needs to be discussed. It may not need to be an option. You may not need to discuss the pros and cons of each option in every case, in particular if it has been agreed that it's not appropriate or in a viable way forwards. A patient can expect to be provided with the advantages and disadvantages of the chosen course of action, and the information provided should be considered reasonable to a person in that patient's position. These are careful balancing decisions, and you're making with your patients, and we would advise recording the rationale behind the decision in the records that you make. It's also important to explain the limitations you might be experiencing, like the availability of AGP appointments. It can be limited. We do understand that a growing number of our members are facing difficulties actually organising enough appointments for their list of patients. So it's something a patient would need to be informed of going forwards. It can seem an onerous task to explain all of the treatment options with the pros, cons, risks of every option, and providing all of the information. It is something that it can seem like a good alternative to save time in the surgery, to provide all the information you would need to on a consent form. But one of the problems with the consent forms is patients will often state that they haven't read it. Although it seems like a time-saving solution, it can cause difficulties. Consent forms can obviously be helpful. They provide the information in a different form to just verbally. You're also giving it to them in writing, but it shouldn't be used as a substitute for the discussions. During the discussions, it is expected that the dialogue is two-way, so you're involving the patient, you're asking the patient questions, they're asking you questions, and it's important to document all. It's important to make full notes, as I've said throughout, and it's important to fully document your discussions, which would include trying to ascertain whether the patient fully understands everything that you've discussed. You've also got to be careful with auto notes. They do save time, and they are a sort of a good way of getting the majority of the information down, but you do need to edit them. You've got to take care. As dental-legal advisors, we often see auto notes including patients being warned of a tuberosity fracture when a lower tooth is being removed. So you have to bear in mind that irrelevant entries within your records could undermine the perceived accuracy of the rest of the detailed record you've made about the consent process. It is something we do see criticisms of in regulatory proceedings and in legal matters. Focusing on the individual patient is a key highlighted by the Montgomery judgment. The consent process should be tailored to your individual patient. It's a two-way conversation involving the patient in the decision. As I said before, it's important to document both sides of the conversation as much as you can, any important points you discussed, any questions they asked, and whether the patient confirms they understood if you were uncertain on any point. So, as I said before, it's important to ascertain that the patient fully understands the information you've given to them, and it can often help by asking them to relay back the information you've given them to satisfy yourself it's been understood fully. In order for the consent process to be valid, the three principles I explained earlier in the Venn diagram on one of the initial slides must be satisfied, and your notes made of the discussions with the patient are key to being able to demonstrate this. One of the important areas to be aware of is that all dentists have a preferred treatment. You may love endodontic treatment and hate extractions, but it's important not to allow your own preferences to influence the patient's decision. The discussions and decisions taken during the consent process should be fully recorded in the patient's notes. Failure to obtain consent can leave you vulnerable to criticism in both regulatory proceedings and legal proceedings. So it's important to evidence that the proper consent process has been followed fully. To reiterate the point yet again, the documentation of the discussions is the key piece of evidence that the patient has consented to the treatment. This is because the discussions determine whether the consent is valid, and the notes you make actually evidence them. The GDC make it explicitly clear that written consent must be obtained when sedation or general anaesthetics are provided at standard 3.1.6. So it's important that you realise that a consent form does not replace a fully informed discussion except in one circumstance. So the capacity laws across the 4 nations are very similar. In England and Wales we have the Mental Capacity Act 2005. In Scotland it's the Adult with Incapacity Act 2000, and in Northern Ireland it's the Mental Capacity Act 2016. They are all very similar. But say in England and Wales, capacity is the ability to make a decision when called upon to do so. Every adult has the right to make their own decisions, and it must be assumed that they have capacity to do so unless it's proven otherwise. Included in this is we might have an opinion that a patient makes an unwise decision, but this does not necessarily mean that they have impaired capacity. So it is that during your discussions, if it does seem like the patient's making an unwise decision, you may wish to clarify that with the patient, provide further explanation, and make certain that is their decision. But it is you do need to accept that if it is ultimately shown to be the case that that is the decision that they certainly want. If necessary, you need to be able to give patients help to make their own decisions. This might help mean using sign language, getting an interpreter, etc. And the capacity is decision and time specific. Patients can lack capacity at a particular point in time, and it may change throughout your course of treatment. So it is something that you need to be aware of each time you're treating a patient. It's important to determine if capacity is impaired at the time the decision needs to be made. So a patient would need to be able to demonstrate that they understand the information about the decision that needs to be made about the particular treatment you're discussing, retain the information, weigh the information in the balance against the pros and cons of that particular option and against alternative options, and communicate their decision. As I said before, capacity might be temporary, or incapacity might be temporary or permanent, so you'd need to make sure that this is assessed at each different appointment. The Mental Capacity Act has 5 key principles. The first, said previously, is the presumption of capacity. You need to provide the patient support in decision making and accept unwise decisions. So you may wish to clarify the unwise decision fully, but document your discussions carefully with the questions you ask and the responses you're giving. You're given by the patient. The principles 4 and 5 are really dealing with a patient who has incapacity, who's been demonstrated to have incapacity. You shouldn't restrict them from having treatment, and you're expected to act in the patient's best interests and take the least restrictive option according to their freedoms and rights, etc. So it is we can obviously advise further in these difficult situations of what you would need to consider. So please don't hesitate to contact the DDU if you're experiencing problems with somebody who you do feel lacks capacity. So in Scotland, it's the Adults with Incapacity Scotland Act 2000. It's very similar, as I said previously. The Act talks about adults who are incapable by reason of a mental disorder or inability to communicate due to a physical disability. Pain, illness, or an underlying condition such as dementia do not necessarily render a patient incapable of giving consent, because those disabilities can be variable. It's important to remember that capability or capacity is dependent on the particular decision being made, and that they can fluctuate with the patient's condition, and it may affect the patient's capacity at any given time. Patients must be given support. You need to be able to demonstrate that you've tried to support the patient as much as possible, and maximise their ability to make decisions. Even if the patient lacks capacity, they must be involved in the decisions about their care and treatment insofar as they want or are able to. In Scotland, adults who lack capacity are protected and empowered by the Adults with Incapacity Act. This aims to support their involvement in making decisions about their own lives as far as they're able to do so. These issues are often complex, as I said previously, so please don't hesitate to contact us if we can help with any unusual situations you're faced with. In Northern Ireland, we're dealing with the Mental Capacity Act 2016. Came into operation slightly later in December 2019, and again, it's fairly similar to the other acts. Where there's doubt over whether a patient has capacity and what action might be in their best interests, we can advise further. Patients who lack capacity, the important thing to consider is that the patients who lack capacity should not be denied necessary treatment simply because they're unable to consent to it, and treatment needs to be provided that you would consider to be in their best interests. One of the other main points to consider: children and young people. So in England, this is anybody under the age of 16 or 18 in Northern Ireland. It depends on their maturity. If they're under 16, you may consider them to be Gillet competent, where they understand the nature, purpose and hazards of the procedure. If you have a patient where they are seeking to consent to the treatment themselves, it is advisable to persuade them to involve the parents wherever they possibly can. And again, if you face situations where you're uncertain what to do, in a situation where a patient under 16 is attending your surgery alone, we can advise on any action that you might need to take. Any treatment you do provide needs to be provided in the patient's best interests. That's really throughout all the different legislation. With consent, you've always got to be seen to be acting in what would be considered to be the patient's best interests. If a child can't consent, then consent should be sought from somebody with parental responsibility. Only the authority of one parent is required in most situations. Obviously, involving both parents can reduce the potential for any conflict to arise between the views of either parent. Obviously, complex situations can arise depending on the relationship status between the different parents, and again, we can advise on any difficulties you might face. The decision must be considered to be in the patient's best interests, and if there is a parental disagreement, it might be necessary to seek a decision in the court, and you should always try and involve the child in the decisions. So who has parental responsibility? The birth mother always has parental responsibility. Married fathers, even if they're subsequently divorced, have parental responsibility. One thing I missed off from these points is that fathers, if they are, after 2003, if fathers are named on the birth certificate, they also have parental responsibility. Adoptive parents and have parental responsibility, but that is parental responsibility is lost from the birth mother and the child's father if the child is subsequently adopted. And parental responsibility can be removed by the court. You'll often face a situation where children arrive to the surgery without their parents, and they come with somebody else, perhaps a grandmother or grandfather, and it is something we deal with quite commonly, where we get asked the questions: who can consent on behalf of the child if the direct parents aren't involved? So the Children's Act 1989 allows a person who has care but not parental responsibility to do what is reasonable in all the circumstances for the purpose of safeguarding and promoting the child's welfare. It doesn't need to be confirmed by the parent in writing, but it's probably better if it is. It avoids conflict if there is a difference of opinion between the grandmother and the mother. So it is often better to try and confirm with the parents wherever you possibly can, wherever this sort of situation arises. So the GDC standards, they specifically delve into communication, which is obviously a major part of consent, and consent itself, and they set out what they expect of registrants. There are 9 principles. 2 and 3 deal with this: communicating effectively with patients and obtaining valid consent. The communicating effectively with patients is dealt with at standard 2.3. A lot of it is what you consider common sense. You will all tailor your language to patients accordingly. It's something you're taught from dental school, and you will often sort of do without thinking. But they set out exactly what they would expect, which is not using professional jargon or acronyms, using an interpreter where possible. If you have patients who are deaf and use sign language, you can suggest that somebody attend the appointments with them with sign language to help patient understanding. Obviously, we have a huge variety of patients we'll treat. Some will like things to be explained in very simple terms. Others, if you use the simple terms, can become prickly and feel patronised if you make things too simple. So your discussions need to be tailored to the individual. Because of where I work, I have a number of solicitors and barristers as patients who deal with medical and dental cases, and their knowledge is sometimes scarily good. But it's important not to presume understanding or knowledge and confirm that the patient understands the discussions fully. Again, documenting any questions that you ask the patient, any questions that they ask you, documenting that fully in the notes is something that can certainly help if difficulties do arise at a later date. So GDC standard 2.3.4 states that you should satisfy yourself that patients have understood. This is, as I keep saying, is evidenced by you documenting that in the patient's records. So any question, if you're ever uncertain about a patient's understanding, if you're sort of relaying the information back and it becomes apparent that the patient might not understand, document what how you've tried to then ascertain whether the patient understands the information fully. You should make sure that patients have enough information and enough time to ask questions and make a decision. Sometimes that means delaying the treatment if the patient is uncertain or hesitant about a treatment option. It would be advisable to give them time to consider the options, offer to discuss things more fully with them if needs be, and again document anything like that in the clinical record. So if the decision isn't forthcoming from the patient, document that you then allowed them further time. So it can often help in a situation if a patient ever tries to complain that they felt pressurized into making a decision. If you've documented clearly that you gave them further time, that would be a difficult argument for them to make. So that's standard 2. Principle 3, or standard 3, then goes on to actually detail exactly what the GDC expects in obtaining valid consent. It is the sort of take-home message throughout the standards is that it's an ongoing process, right from the start of treatment, making sure that the patients understand the decisions that they're being asked to make, and that you need to make sure that it remains valid at each stage of the treatment. Patients are obviously often returning for multiple visits. They might be seeing multiple members of the team, other registrants. So it's important for each registrant to make sure that they are comfortable with that the patient has consented to the treatment they are being asked to provide. So that point is dealt with at standard 3.1.1, making sure that the patient's valid consent before starting any treatment, and then any subsequent team members who treat the patient. It's important not to assume that somebody else has obtained patient's consent on your behalf. That should be confirmed at the beginning of the appointment. although we've said it many times so far, the GDC specifically state at 3.1.2 that the discussion should be documented, and they go on to explain that a signature on a form is important in verifying the patient is given consent, but it is the discussions that are ultimately the important, or they consider this to be the important thing. You must check and document that patients have understood the information you've given, so that would be through the questions you might ask. Patients also have the right to withdraw consent at any time, refuse treatment, or ask for it to be stopped after it's started. It can be frustrating if this happens sort of during treatment itself, but it is something that you need to respect if a patient does wish to withdraw their consent for any reason. Obviously, documenting it carefully, your discussions with them around that, the reason why they want to withdraw their consent is important if they go on to complain afterwards. So it's important to try and discuss things with them of why they wanted to withdraw their consent at any point. As briefly mentioned earlier, there's just the one situation where the GDC expect you to obtain written consent, and that's where treatment involves conscious sedation or general anaesthetics. Although it's something we're obviously acutely aware of at the moment with the consent process, it is something that our regulator has always been a principle they define. Going back to 2005, find out what your patients want to know as well as telling them what you think they need to know, which is really sort of going beyond the treatment. You might have expert knowledge in a particular treatment and be able to provide them with further information that might alter their decision once they know that information. So it is always important to bear in mind that patients, if there is information that might not be immediately apparent that would normally be discussed in a particular treatment, but you think it might be relevant for this particular patient, it would be important to discuss that. There's obviously a fine line to tread, and it can sometimes feel like the consent process takes longer and is more onerous than the treatment itself. Although the vast majority of patients we treat won't have cause to complain or attempt legal action, making sure your consent process is robust and well documented can ease the stress and avoid a justifiable criticism if a patient does attempt either legal action against you, a complaint, or a regulatory matter. The power of attorney, these are particularly complicated. You can have multiple people acting with power of attorney for different types, financial affairs, health, etc. So it is something often you'll need detailed advice from us about those. So if you do, I've never come across it in practice yet, but I have dealt with a number as an advisor. So if you do come across with power of attorney, then we are obviously able to advise, give individual advice depending on exactly what you're being presented with, and we're more than happy to advise on these if you face any difficulties. So in summary, valid consent is essential to care. It's something that's been part of dentistry historically, and it's something that's been evolving since. And as I said, with the most marked change since the Montgomery judgment. You need to take an individual approach. Patients vary enormously. Some people will have a lot of dental knowledge before you treat them. Some won't. Some patients will need things to be explained to them in a simple manner, or might need extra support. So you need to use an individual approach and explain the risks involved in the treatment you provided. You have to assume that all patients have capacity. And capacity is time and decision specific, so you need to make sure that is current at the time you're providing treatment. Children can consent if they are competent to do so, and as I've mentioned several times, it is important to the most important thing from my point of view as an advisor is to document the discussions and decisions fully, including the questions you're asked, because it is something sometimes patients will forget that they did clarify this with you at the beginning, beginning of treatment. So it is certainly something that in my role I've seen is one of the most important things in the consent process is actually documenting it all carefully, because it does make defending any difficulties that arise far easier. You're obviously not alone. We're here to help with any difficulties that arise. There are a huge number of scenarios that present themselves. Some can be very unusual, and we're more than happy to talk through the approaches to different things and guide in the way you can approach particular matters, and what you need to do, what you need to be aware of for all of these difficulties that do arise. It can add a lot of stress to an already stressful job, just dealing with the consent process or particular situations that arise, like powers of attorney, etc. Patients who are incompetent and something or lack capacity where you need to explain things in particular way or take particular action. So we're more than happy to advise. These are questions we get asked commonly, and the situations that arise quite frequently in practice. So one of the questions we get asked very commonly is, I have a number of patients who attend for appointments with a grandparent or other family member while their parents are at work. Who can consent to treatment for these children? So this is something we dealt with it in one of the earlier slides. The key point is that the Children's Act 1989 allows a person who has care but not parental responsibility to do what's reasonable in the circumstances, safeguarding and promoting a child's welfare, which is effectively consenting to treatment on the child's behalf. It is advisable to involve parents wherever there is a decision to be made that, say, a situation arises where an extraction is advisable. It is something that, obviously, if a child goes home with a tooth missing, parents can then often be alarmed, and difficulties can arise with complaints, etc. So, although it doesn't need to be confirmed by a parent in writing, it's probably better if it is. It does make sure that all parties are aware of exactly what treatment's being provided. If something irreversible is considered to be in the child's best interests, but you can delay that for a period with something that where you can alleviate pain, etc., but delay the extraction. So if you can extirpate and then extirpate a pulp and then potentially extract the tooth at a different time where you can involve the parents in the decision, that can often go some way to reduce the potential for any difficulties to arise. So another question we get asked commonly is, patients, particularly patients when they're in extreme pain, you can feel like they're making a decision in haste because of the difficulties they've experienced. We do see patients where they're in excruciating pain, but you feel like a tooth can be retained with endodontic treatment and restored with a good success rate. What do you do in those situations where you feel like the patient is making a decision in haste? So again, similar scenario to the previous one. If there's a way to alleviate the pain immediately and delay the irreversible decision to extract, is that a possibility? It's an option you may wish to discuss with the patient, but then ultimately the patient has to consent to that alternative. As I explained earlier, a patient may make a decision that you don't consider is to be a sort of a reasonable decision, or not one that you would consider to be something you would personally like yourself. You've got to bear the patient's opinion in mind and explain everything sort of quite carefully to them. Do you consider the options presented, including the option to delay a decision, to be in the patient's best interest? So you've always got to have the patient's best interests at heart. Explain what you would consider to be appropriate for the patient, but ultimately accept their decision, even if you think it is unwise. Again, document everything carefully. If a patient is making an unwise decision and you have discussions around that unwise decision, make it clear in the records. what your discussions were and the attempts you made to confirm that that is actually the course of action they wish to pursue, and the options you presented to potentially delay that treatment to give them time to consider it and get them out of pain in a different way. Document that carefully, that you've presented that as another option. So third scenario, and this, say, I've been asked this several times. I'm sure lots of other people have, where patients have partial dentures. They have a currently stable but heavily restored dentition, where they may be getting sick of having other dental treatments. They think having dentures is a way to avoid any future dental treatment. They're currently stable, and the patient pressurizes you into extracting the remaining teeth and making full dentures. What should you do? This scenario is one really of elective treatment. So you've got to consider, is the treatment in the patient's best interests? If it isn't, you need to explain that to the patient and politely decline their request, obviously explaining everything quite carefully, why you don't consider it appropriate to remove the remaining teeth, like preserving bone for the future, and that their teeth are currently stable. And again, document your discussions carefully with the patient. The patient's request, all your explanations of why you don't consider that to be in their best interests, like preserving bone levels, etc. Make sure everything is documented carefully, because then these patients, if they don't get their request, are some patients where there is a potential increased risk of a complaint being received, which is generally quite straightforward to deal with. If everything's been documented carefully, we can deal with that quite easily. So key point throughout all of this is to document your discussions with the patients very carefully throughout, and including any clarification you might make of particularly any unwise decisions, etc. So that's the end. If you'd like to contact us, our contact details are below. More than happy to answer any questions if they do arise. And thank you for your time.